Dear friends, today we are beginning with the 2-mark questions of administrative law. These short answers are designed to make your learning simple and effective. You can even make your preparation easier by listening to these answers again and again. So let's begin with our very first question in administrative law. Define administrative law. Administrative law is a branch of law regulating the powers and duties of administrative authorities and their relationship with citizens. According to Dicey, it is that part of law which relates to the control of administrative authorities. Jennings describes it as a law relating to the constitution, organization, powers, and duties of administrative authorities. Watkins defines it as the law which governs the functions of public officials and agencies in carrying out public duties. Glanville Williams emphasizes its role in controlling arbitrary action and protecting individual rights. Judicial recognition in A.K. Gopalan v. State of Madras 1950 highlights legality, fairness, and accountability. Now we move on to the next important short question. What is Droit administrative? Droit administrative or French administrative law governs the organization, powers, and duties of public administration and regulates interactions between the state and citizens. Originating in 19th century France, it developed through the Council d'État to separate administrative disputes from ordinary courts. Its key features include specialized administrative courts, judge-made rules, administrative discretion, and judicial review of administrative actions. Other characteristics are protection of public officials, state liability for wrongful acts, service public, that is serving public interest, and independence from precedent. This system ensures efficiency, legality, and fairness in governance while addressing complex administrative matters effectively. Here comes another key question you should never miss. What do you understand by injunction? An injunction is a judicial order directing a person or authority to do or refrain from a specific act, protecting rights and preventing harm. Permanent injunctions remain enforceable until modified or dissolved. In administrative law, injunctions control administrative action, preventing abuse of power. Courts issue them to restrain ultra-vires acts, enforce legality, fairness, and natural justice, and balance public interest with individual harm. For example, in Smita Sabharwal v. Telangana Government 2025, the High Court restrained adverse action against an IAS officer, highlighting judicial oversight, protection of rights, and enforcement of statutory compliance in administrative matters. Let's take up the following question and understand it briefly. What is speaking order? A speaking order is a judicial or administrative decision that clearly states the reasons for its conclusion, ensuring transparency, accountability, and fairness. It is vital in administrative law to uphold the principles of natural justice and enable effective judicial review. For example, in September 2025, the Maharashtra Administrative Tribunal reinstated a police head constable who was dismissed without a departmental inquiry. The tribunal held the dismissal invalid, emphasizing that administrative decisions affecting service conditions must be recent and based on objective material. Now friends, listen carefully to this 2-mark question. What is subdelegation? Subdelegation occurs when a public authority entrusted with powers under a statute further delegates those powers to another subordinate authority. It is generally prohibited unless expressly authorized by law to prevent misuse and ensure accountability. For example, in S.P. Gupta versus Union of India 1981, the Supreme Court emphasized this discretionary powers delegated by the government cannot be further delegated without statutory sanction, ensuring proper exercise of administrative authority and safeguarding citizens' rights. We shall continue with the next short question in sequence. What are the different types of public corporations? Public corporations in administrative law are statutory bodies created by acts of parliament with separate legal identity. They combine government ownership with business-like operations to provide essential services such as transport, healthcare, banking, and insurance. Their features include autonomy, accountability, service orientation, and funding from both government and public sources. Advantages include public welfare, large-scale operations, reduced financial risk, and job creation. However, they often face challenges like bureaucratic delays, political interference, inefficiency, low profitability, and weak customer focus. The upcoming question is a common one in exams. Write the concept of legitimate exception. The doctrine of legitimate expectation, first noted by Lord Denning 1969, safeguards fairness in administrative actions. It arises from promises, consistent practices, or policies of public authorities giving individuals a reasonable expectation of fair treatment. Recognized in England and India, it operates both procedurally and substantively. Though not an enforceable right, courts use it under Article 14 to prevent arbitrariness, subject to overriding public interest, ensuring transparency and accountability in governance. Here is another interesting question to sharpen your understanding. What is post-decisional hearing? A post-decisional hearing means giving an affected party the right to be heard after an administrative decision has already been made. It is an exception to the principle of audi alteram partem, hear the other side, which is the basic part of procedural fairness or rule of law, where pre-decisional hearing is not possible due to urgency, public safety, or administrative necessity. The purpose is to balance administrative efficiency with natural justice, the validity. Courts accept if immediate action was required, provided the hearing afterward is real and meaningful. An Indian example, Menaka Gandhi versus Union of India 1978. Her passport was impounded without prior hearing, but the court held a post-decisional hearing could satisfy natural justice in urgent situations. Let us take the next question and see what the answer is. Who is an ombudsman? An ombudsman in administrative law is an independent and impartial authority appointed to investigate complaints against governmental agencies, officials, or public bodies. Originating in Sweden 1809, the Ombudsman ensures fairness, accountability, and transparency in administration. Key functions include resolving complaints, mediating disputes, and scrutinizing executive actions. They also identify systematic flaws and recommend reforms. In India, the Lokpal and Logayuktas Act 2013 created ombudsman bodies to address corruption and maladministration, providing citizens a free, accessible redress mechanism and enhancing public trust. Moving forward, we read the next short question. What is doctrine of laissez-faire? The doctrine of laissez-faire means leave alone, where the state interferes minimally in economic and social life, limiting itself to law, order, and security. It emphasized free trade and competition. However, this led to exploitation, inequalities, and hardships during crises like the Great Depression. As a response, the welfare state emerged, ensuring public welfare, social security, and economic justice. Thus, laissez faire gave way to state intervention to balance freedom with social responsibility and protect weaker sections. Dear friends, with this, we conclude today's set of 2-mark questions in administrative law. We will be back tomorrow with another fresh set of questions. Till then, stay connected with Nyayacharya. If you enjoyed this podcast, don't forget to subscribe and be part of this learning journey. Your suggestions are always welcome. Do share them with us. Thank you for your listening.